Excellent, cool. So yeah, good morning. Nice to see you all again. So yeah, as Phil says, I'm just going to talk a little bit about disrepair claims. Now, some of you may know about the subject already, I understand that, but some of you may not, might be quite new to you. So the risk of a disrepair claim materialising would probably sit within your housing teams, but it could equally sit within finance or legal teams maybe. And I must stress, I'm not a legal expert, so this is not a legal advice webinar, nor is it about the actual process in dealing with a disrepair claim if it happens, although I can touch on that a little bit. So it's generally signposting you so that you're aware of the risks around disrepair claims and the mitigations and strategies that you should have in place to be able to either defend them or prevent them from happening. Okay. So what is a disrepair claim? So a disrepair claim is a legal action taken by a tenant against their landlord because of a failure by the landlord to address a reported repair within a reasonable amount of time. And Section 11 of the Landlord and Tenant Act defines a disrepair as the condition of an item that has deteriorated. So that means it's in a worse condition now than it was before. And receiving a disrepair claim is generally a financial risk to your organisation, but one which would also have a huge reputational impact if it materialised. As a less common action, the tenant also has a choice to bring a statutory nuisance claim, which could result in a personal injury claim under Section 3 of the EPA. And it should be noted here that the EPA covers both actual and potential injury and physical and mental health issues as well. So a disrepair claim can include things like anything structural, such as cracks or other structural defects to the property. It can include damp and mould issues, which can cause health problems. It could also be indicative of other damage to the property, for example, faulty guttering. If you've got mould within the house, it could mean there's a bigger problem on the outside. It can be drafty windows or doors, such as broken seals or faulty locks. Heating and hot water problems, such as faulty boilers, lack of hot water for any other reason, or leaks within the water system. We've got their electrical faults, such as unsafe wiring or faulty appliances, if they're included in the tenancy, and pest infestation, so rats, mice, things like that. And if the landlord does fail to address any of these reported repair issues, then tenants have various remedies. So firstly, they'll engage a solicitor to submit a disrepair claim. They may withhold paying rent to you as a landlord and then use that money to repair themselves or pay for repairs through private contractors. But that rent money would then be held in an account and they would use it from there. Or they might take it on themselves to withhold the rent in protest to try and force you to carry out repairs. And of course, tenants can then submit a complaint and ultimately refer you to the Housing Ombudsman if they no satisfaction's received. But following legal action, if it goes down that road, the courts could order. So they could order damages by way of reduction or reimbursement or percentage of the rate of the rent. They can make an order for specific performance, which is basically ordering a landlord to carry out certain repairs. The courts can also award damages to the tenants, including any legal costs that they're potentially liable for, and also any compensation to the tenant for any loss suffered. So that could be replacement of furniture or clothing, anything that's been damaged. So a quick look at the relevant legislation and guidance surrounding disrepair claims. So firstly, Section 11 of the Landlord and Tenant Act 1985. So landlords would be in breach of Section 11 if they had notice of a repair, but then failed to carry out the repairs in a reasonable time. So a report of repair can simply be a tenant verbally conveying it directly to the landlord or any of its agents. So any visitors to the property, like neighbourhood housing officers or contractors, the tenant can verbally tell them there's repair to be done. And that oral notice is sufficient. There's no obligation on the tenant then to chase that repair once it's reported. So it's really important to build those internal relationships between everyone who's tenant facing, just so that everyone is aware and information is shared and forwarded to the right teams and right people. A disrepair claim could also be brought under Section 4 of the Defected Premises Act 1972. And this particularly covers things that the landlord should have known about, but hasn't acted on or kept maintained. For an example of that would be Finlock concrete guttering, or things that are pertinent to a particular property archetype. So things that the landlord should know about and should be maintaining. Then we have the very recent AWAB's law, which I'll cover in the next slide. You have your tenancy agreements. So clauses within your tenancy agreements can be used to enforce access to enter a property to carry out repairs, but they'll also outline the tenant responsibility and the landlord's obligation in relation to repairs. We've also got a pre-action protocol, which I'll also cover later on, and then Section 3 of the APA, which I mentioned earlier around personal injury claim. So landlords have been faced with significant changes in legislation recently, imposing greater obligations and responsibilities on them. And the Social Housing Act largely came about due to the tragedy of Grenfell and the death of Awab Ishaq. And that act has 7 chapters, which encompasses the objectives of Awab's law, with a particular focus around damp and mould, which I'll give you a bit of an overview here. So the new legislation does require landlords to comply with new stringent requirements. And as we know, if they fail to meet those requirements, the tenants can take legal action for breach of contract. So AWAB's law has therefore been really instrumental in a significant step forward to improving housing standards across the UK. And it's to ensure that all tenants have the right to live in safe and healthy homes. And damp and mould issues have been the driver behind this. So the key aspects. So AWAB's law requires social landlords to investigate and remedy health and safety hazards such as mould and damp in their properties within quite strict timelines. The consultation also set out proposed time limits for landlords to inspect and report on potential hazards that have been brought to their attention. And where a significant risk has been identified, then there's been proposals around completion of any required works. If a landlord fails to comply with AWAB's law, their tenant can bring a claim for breach of contract, as I mentioned, for damages, and they can also report the matter through the Housing Ombudsman Service. And the law provides stronger enforcement powers to local authorities, allowing them to take action against landlords who fail to comply with these new housing standards. And action can include hefty fines and even criminal prosecution in really severe cases. And if the landlord happens to be a local authority, then the Housing Ombudsman or the Social Housing Regulator would therefore investigate instead. And then AWAB's law will also encourage greater engagement from the tenants, giving them a stronger voice and ensuring that their homes are safe and habitable. So strong contractual safeguards can help protect landlords against liability in the event of a disrepair claim notice. So tenancy agreements should be clearly defined. The tenant's obligations for maintaining the property should be very clear, including any routine cleaning, minor repairs, things like that. They should also specify the landlord's responsibilities for repairs and any structural maintenance to ensure the property is safe, secure and habitable. You should have a good complaint dispute resolution clause, which should clearly outline the process for addressing any disagreements between the two parties. An inspection report should be obtained before and after a tenant moves in to document the condition and the history of that property. Through the Ministry of Justice, there is a pre-action protocol, and disrepair claims must follow the pre-action protocol for housing. And if you don't, the courts will see that as very, it'll go against you in court if you haven't followed this, basically. So any court proceedings, very detrimental, basically. So what is the protocol? So the protocol states that a letter of claim should be sent to the landlord at the earliest opportunity, and upon receiving that, the landlord must respond with disclosure any documents that have been asked for within just 20 working days. Both parties are encouraged to exchange information regarding the extent of the disrepair and any proposals for the work to be done. And in all cases, an independent expert will be engaged jointly or separately by both parties to assess the disrepair and to recommend any solutions. And the protocol also encourages parties to negotiate a settlement without going to court, which can obviously save time and hefty legal costs. So why should you follow the protocol? Well, basically, it's a legal requirement, so you must follow the protocol. Failure to do so can result in penalties, such as bearing the costs of all the proceedings, and it also sets out the framework to resolve matters within reasonable timeframes. It also helps to clarify the issues in dispute, making it easier to resolve. And by encouraging the early communication, the protocol tries to lead to a faster resolution, thus reducing the costs in court. So to summarise the aims, to avoid unnecessary litigation and free up the courts, promote the speedy and appropriate carrying out of repair works that are the landlord's responsibility. It's to ensure tenants receive any compensation they're entitled to as quickly as possible. To promote good pre-litigation practice, including the early exchange of information. Give guidance about the instructions for the experts, and obviously keep the resolving disputes cost to an absolute minimum. So that's the background. Just going to look at the risk management side of it now. So obviously a comprehensive risk assessment is going to be essential for identifying potential areas of vulnerability and for developing effective mitigation strategies around your repairing obligations. So breakdown of the steps here. So you need to conduct thorough property assessments, including age, condition, and any known maintenance issues. You need to evaluate the potential severity of any risk, consider the factors like the financial impact, the tenant safety, and the reputational damage that can be caused. And then you need to know your internal disrepair process. So everyone in your organisation needs to be aware of this. Your repairs inspectors, your neighbourhood officers, your legal team, all your contractors, your planned maintenance surveyors. Everyone needs to know what a disrepair notice is if it arrives, and how to take immediate action. Remember, you've only got that 20 days to deal with these. So everyone needs to be aware. And how would this look on your risk register? So I've done a few examples here, but of course they'll be pertinent to your own organisation. And I've thought about a few objectives, such as one of your objectives might be to keep homes compliant with a decent home standard, or ensure all homes are safe and habitable. And another objective might be open communication with tenants, so understanding their wants and needs. So, for instance, mould and damp and mould, you can't just assume it's a lifestyle problem. There could actually be a repairing problem that needs to be dealt with. So it's keeping that communication open with your tenants. So I've put a few examples here. At the top one here, I've highlighted a few bits just to talk about. So no process in place. So one of the things is you must have a disrepair process in place to deal with these within the council, whether that's an allocated manager or an allocated team, but somebody needs to take charge and make sure things are done within the timescales. I've put in here bad contractor practice, comes down to contractor relationships maybe, but you might have a contractor that books an appointment to go and deal with a repair. They don't turn up, or the tenant's not in, so it gets rebooked, they don't turn up again, and the clock is ticking. Budget constraints, you might have these days a lot of budget constraints, especially in repairs. So sometimes there might be decisions on which repairs to carry out and which ones not to carry out. That's just something to be aware of. You might not have the budget to do everything. So those decisions might be quite costly in the long run, but they're things to think about. And I've also put there not knowing your silences. So these might be people that the tenants, the very quiet tenants that you never hear from. There may be hoarders. They don't want people in their properties. And even if you did manage to get access to the property, the chances are you wouldn't be able to see where any damage was or any repairs that need doing. The other thing is that when a contractor goes to the property and maybe goes to fix a tap, there might be other issues at the property that get reported. So he might be there to fix a tap, but if he's missed the broken door lock and hasn't reported it, then that's an issue for the future as well, and that could lead to a disrepair. So it's just being aware, everyone being aware that these things can happen, and a tenant can already tell you about stuff. And just be aware of disrepair notices, and make sure your contractors are aware as well. So the mitigations and strategies to help you deal with this. So alongside identifying the risks, it's obviously important to develop some robust mitigations and strategies, and a proactive approach, as I've said, can significantly reduce the risk of a disrepair claim being received. So property inspections or tenancy audits, they should be carried out at least annually. They should cover all the internal and external areas of the property, and the results of any inspections, they should be recorded and shared with the tenant as confirmation of the matters discussed and agreed. And then that will set your backstop date for any future claims of disrepair. So at that point, everything's okay, tenant has no further repairs. That's your backstop, okay? You should have an effective responsive repair service in place, which should be easy to access by the tenants, and it should offer advice and help as well. So all channels for reporting repairs should be accessible and should be easy, so as to encourage tenants to report repairs promptly. So that might include smartphone apps, out of hours contact centres, website reporting as well. Your contractual safeguards that I've spoken about, such as tenancy agreements and maintenance contracts, they should be continuously reviewed to reflect any current guidelines or new legislation. Training should be provided to all officers within the organisation that are in tenant contact. So that again will be your repairs inspectors, neighbourhood officers, legal teams even, just around the awareness and legislation in respect of disrepair claims. So you have that 20 working days to deal with a claim notice. So once that's received, it needs to be dealt with as quickly as possible. And as with all your other risks, they should be regularly reviewed, updated, and with your mitigations as well, regularly reviewed and updated. So a robust and comprehensive preventative repairs and maintenance programme should be in place to address potential issues before they arise. You should also have policy and procedures in place for handling disrepair and EPA claims. So a designated person should be coordinating this and making sure repairs are carried out, making sure the training's in place, all of those things. There should be an effective, accessible and transparent complaints process in place. All complaints should be responded to in a timely manner, following your own organisation's complaint process and following the Housing Ombudsman's Code of Conduct. Hopefully you've all got some kind of CRM or documentation system in place as well to keep detailed records of all repairs and property history. This allows internal collaboration and reporting. It will also allow or make it a lot easier to collate evidence if you do have a disrepair claims notice come in. everything's in one place and you can pull it all out again. If you haven't got that in place, you could be running around everywhere looking for different reports, different sort of inspection reports, different dates, all that sort of thing. So if you've got it all in one place, it's easily to grab it on that first disclosure, which will be part of that first disrepair notice that comes in. As mentioned before, there needs to be good internal working relationships between all your internal teams involved. Contractor relationships with the organisation's repair maintenance teams. They need to adhere to industry standards and best practices. Quality control inspections, conduct these after repairs or renovations to verify satisfactory completion, make sure the tenant is happy. And then, of course, following quality control inspections, if there's any follow-on remedial works to be done, then that needs to be booked in as well. And of course, a regular review and update of your repairs strategies and your asset management strategies based on any changing circumstances. Now, I just wanted to give you a few quotes from the Regulator of Social Housing's recent risk profile report. I won't read them all out. I'll let you read and digest. So it's quite a lot of information there. But you'll also find plenty of information across the government and the Social Housing Regulator websites. So it's just a quick summary before I close. So disrepair claim, legal action taken by a tenant against their landlord, generally a financial risk, but with a huge reputational and financial impact. Could lead to a landlord having to pay compensation and damages, which can be quite hefty. And separately, the Housing Ombudsman could also issue a maladministration order if complaints processes are not followed correctly or in accordance with their code of conduct. And any landlords that are named and shamed on their website as well. And then the mitigations, be proactive, robust repairs and maintenance programme in place with an easy to use and accessible housing repair service for tenants. Carry out regular property inspections or tenancy audits and review your contractual safeguards around tenancy and contract arrangements. And very important, ensure all your staff are up to date on their training, especially around legislation and housing protocol in relation to the disrepair claims. Can't stress enough how important communication is within your legal teams and with your internal teams as well. All staff just need to recognise a disrepair claim notice when it lands on your doormat. They need to know how to act or who to give it to ensure that it gets dealt with as quickly as possible when the clock starts ticking for those 20 days. So that's me. I'll hand you back to Phil.
Wonderful. Thank you, Sandra. That was really interesting. It's given me a bit of a insight as well into something I was aware of, but yeah, it's been really good to get some more information. Obviously, what Sandra was talking today was about the use or the management of risks associated with disrepair claims. And she gave some examples there how these could be managed and looked at within your risk registers. So if you want to have a conversation with us about the use of the JCAD core system for the management of these risks, then obviously get in contact with myself or Sandra. Obviously within LACS, the claims management system, we also have an ability to manage the disrepair claims within the claims system as well. Although not an insurable risk, perhaps, these types of claims can also be managed within the LACS system. So again, if you have an interest in learning more about that, or just chatting to us generally about the claim system, again, get in contact with myself or Felicity. Brilliant stuff. There don't seem to be any questions. There's no hands up. in which case I will say thank you ever so much for everyone for taking the time to spend half an hour with us this morning. We hope you found it useful. Thanks very much. Enjoy the rest of your week, and we'll be back in front of you again probably the next month or two as well. Okay? And thank you, Sandra. That's great.